2022 CR 27A, State versus Mark Carl Rowell. Mr. McAdams.
That'd be a plea.
All right.
Post-trial version.
All right, I've been handed this post-trial diversion, judicial diversion.
Yes.
And I've been handed both the certification that he is eligible. Then at this point, he is going to be entering, according to this agreement, plea of guilty to count 1 under 4035-313 to an amended charge of attempted aggravated child abuse and receive a sentence of 3 years suspended and supervised probation to have no contact with the victim. He must waive. No, he must waive the spousal privilege and testify truthfully against Stephanie Rollins. All right. He waived the spousal privilege to testify against her, or is she the one that has that privilege? That's going to be an interesting legal question. So,
but this part of this, as part of this plea deal, Your Honor,
he has to testify truthfully. I wonder about that. But anyway, Mr. Rowell, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
Oh, thank you. State your legal name, your full legal name, please.
Mark Carl Rowell.
Mr. Rowell, you were here today charged with, you've heard me go over what the agreement is. You understand what you're charged with, and have you and Mr. McAdams been able to discuss the range of punishment you're facing, the evidence the state has against you, and any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to this amended charge of attempted aggravated child abuse. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir, I do.
You understand that if you went to trial, you and Mr. McAdams could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
I do.
You understand that by pleading guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
So that means that you're going to be placed on probation under a specific statute designed for people who have no prior criminal record. And that if you successfully complete this probation of 3 years, then at the end of that time, you can have your record expunged or wiped clean as though this never occurred. You understand that?
I do.
But do you understand that if you violate the terms of your probation, then this will become a permanent conviction? And it could also mean that you could be brought back before the court and re-sentenced within the range of punishment for this offense. And it means you could get more time if you violate your terms of probation. Do you understand that?
I fully understand.
Do you understand everything I've explained to you?
I do, sir.
Do you want to waive your right to a trial and to an appeal by entering this plea?
Yes.
Do you understand if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you were lying under oath.
I understand.
Was your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
Sir.
You understand I have to have facts to support the fact that you're guilty before I can accept your plea.
I do.
And is the state going to tell me what the facts are, or are you going to allow him to testify? Let her step aside and let her step in front of this microphone, please.
Your Honor, the state would put on proof that in April of 2020 here in Stewart County, the victim, minor Gabrielle Norton, Mississippi, with Mr. Mark and Stephanie Rowell in their care. Leading up to that day, she was subject to discipline, which left bruises on her body, malnourishment, and other discipline that be categorized as psychologically damaging to a person, especially a minor, Your Honor. And Mr. Rowell, while Stephanie Rowell was the primary caregiver, that's the state, that's the proof that would be shown by the state. Mr. Mark Rowell was also a caregiver, Your Honor. However, he worked So during the day, so he was not at home for a lot of the actions, but he also was aware of it, did report it at that stage.
Right. Mr. Rawl, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be at trial?
I do.
Do you understand that it's also a requirement of this case that you testify truthfully if you're required to testify at a future trial for any other person?
Yes, sir.
Are you satisfied with your attorney services?
Oh, yes,
Feel like Mr. McAdams has done a good job of representing you confidently.
sir.
Mr. McAdams, you know of any reason you should not enter this plea?
No, sir.
Then Mark Rowell in docket number 2022 CR 27, upon your plea to the amended charge of aggravated child abuse, I find you guilty. Well, actually, I place you on probation for a period of 3 years under 4035-313. That will be supervised probation. You're to have no contact with your victim in this case, and you must waive any spousal privilege and testify truthfully against Stephanie Rowell. All right. He'll need to see the probation. Twenty 31B, State versus Benjamin Sasag.
What page is that? I'm sorry.
It's on page 9. Benjamin Sosag.
Mike must have just stepped out here. I see his hat still out here on the bench.
All right, let's talk about that. This hearing with Judge David D. Wolfe was a methodical but noteworthy one, because it shows how the court balances leniency with accountability in cases where a plea deal is on the table. Judge Wolfe's demeanor throughout was steady, patient, and deliberate. He didn't rush the process and carefully walked the defendant, Mark Carl Roll, through every single right he was giving up by pleading guilty. That's something Judge Wolfe is known for, a no-nonsense approach that still leaves room for ensuring the defendant understands the stakes. He didn't sugarcoat the deal, explaining both the benefit of possible expungement if probation is completed and the consequence of a permanent conviction if terms are violated. It was the kind of judicial balancing act that keeps a courtroom grounded. As for Roll, his attitude was calm and compliant. He answered yes, sir, with consistency, showed no signs of defiance, and acknowledged the weight of the agreement, without trying to argue or downplay his involvement. His body language and tone came across as resigned but cooperative, one who understood that this plea was likely his best path forward. The defense attorney, Mr. McAdams, looked well prepared and steady. He confirmed his client's understanding at every step, and Judge Wolfe even asked directly if counsel had done his job, which Roll affirmed without hesitation. That's always a telling moment, because it reflects not only the attorney's competence but also the defendant's trust in his representation. The state's presentation was straightforward. They outlined the facts they would have put forward at trial, and while they didn't dwell on unnecessary detail, the prosecutor highlighted that Roll was aware of what was happening and failed to act, even if he wasn't the primary caregiver. It was clear, concise, and enough to support the amended charge without drifting into theatrics. One interesting wrinkle was the condition requiring Roll to waive spousal privilege and testify truthfully in future proceedings against Stephanie Roll. That sparked a little side discussion about the mechanics of spousal privilege, an almost academic legal moment in the middle of an otherwise practical plea hearing. You don't always see those kinds of exchanges, but they remind you how layered courtroom proceedings can be, even in cases that seem procedural. The overall atmosphere of the courtroom was calm, bordering on routine, but not without small moments of interest. Judge Wolfe kept the tone professional, the attorneys stayed composed, and Roll himself never strayed into emotional outbursts or visible frustration. If anything, the hearing had the feeling of a box being neatly checked serious. Enough given the charge, but not chaotic or unpredictable. By the end, Judge Wolfe accepted the plea, imposed 3 years of supervised probation, and laid down the conditions firmly, including no contact with the victim and full cooperation if called as a witness later. It was all, in all, a textbook example of how a plea hearing should run. Clear explanation, informed consent, and accountability built into the agreement. Nothing flashy, but plenty of legal substance for those paying attention. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,